and he's not your son. He is your stepson, and you have no parental rights to him. Your Google search does not take the place of my law degree. And State of Nevada versus Kimball Austin Sachs, case number C3435401 and 3435402. Can I get a purpose of counsel on both, please? And Mr. Sachs, I need you to mute yourself until I call your name because I'm getting feedback.
Dena Rinetti for the state.
Thank you.
Good morning, Judge Shetler, 4747 for Ms. Zhang.
Jeff Marchese on behalf of Mr. Sachs.
All right. Mr. Sachs, you can now unmute yourself and state your appearance if you'd like.
Agent for defendant Sachs.
Okay. All right. We are on a couple of things. I need you to mute yourself again, please. All right. We are on for an ex parte application for an order shortening time to hear defendant Zhang's emergency motion to set aside or modify the no contact order with a supplemental motion seeking to regain access to the passport. The state has filed an opposition on that. The court also notes that there were documents that were filed by Mr. Sachs, specifically the joinder to the emergency motion to set aside or modify the no contact order, a reply to the state's opposition to the defendant's emergency motion to set aside or modify the no contact order, a emergency motion to request standby counsel to be advanced to the existing October 20th, 2025 hearing consistent with judicial economy, objection to the September 8th, 2025 hearing and fraudulent issuance of bench warrants, emergency motion to vacate unlawful stay of proceedings, emergency motion to disqualify Chief Deputy District Attorney Dena Rinetti for malicious misconduct, bad faith, abuse of authority, conflict of interest, and ethical violations. There is also a motion in Mr. Sachs's case that was filed for a withdrawal of counsel. The court has read and reviewed. I also note that there were other documents that were in fact filed last night that the court has not had an opportunity to review yet, and it will not be addressed and are not before the court today. To the extent that those other motions were filed last week, certainly the state would have the opportunity to file an opposition to them if the state chose to do so. But I will say this, the court has read them and is prepared to deny all three of them today, and I can state the reasons why on the record. Why are my, okay, they are, okay. I think the first thing that we need to deal with is the motion that was filed by Mr. Marchese to withdraw as counsel. I think that's the first thing that we need to deal with, and it's my understanding that there are statements that were made by Mr. Sachs that he felt that you were not doing what you were supposed to do for him, to the extent that any of the motions that he filed were ones that he asked you to file and that you found them to be frivolous, repugnant, harassing, any of those things, and therefore refused to file them. I would say that his threats to you for failing to file them would be repugnant. Because quite frankly, attorneys have a duty to only file motions that are with merit and are not frivolous and are not harassing. And the ones that I have read that have been filed by Mr. Sachs, first of all, until such time as the court allows Mr. Marchese to withdraw, he doesn't have the right to file those motions. And we have gone through this ad nauseum in other instances prior to Mr. Sachs being represented. And I understand from reading his motion that he says, well, Mr. Marchese wouldn't file them, so I'm filing them on my behalf for purposes of the record. You don't get to do that. That being said, at this point, I don't even know, because I appointed Mr. Marchese and within 48 hours, this all blew up. So I don't even know whether or not there was an attorney-client relationship that was even established, quite frankly. But I don't know if you have had an opportunity, Mr. Marchese, to speak with Mr. Sachs and what your position, if your position is still that you wish to withdraw, but Mr. Sachs does not get to choose his counsel. He gets to have competent counsel, and Mr. Marchese is competent counsel. And if he wants standby counsel, then this court is going to do another Faretta canvas, because quite frankly, the last Faretta canvas was so long ago that I feel that it would be appropriate to do another Faretta canvas in this case. Because the information that had been provided to Mr. Sachs as to the difference of what standby counsel is and what standby counsel can do versus what he would be required to do on his own behalf, are different than what the representations were made to him the last time. And so I think that it would be appropriate to redo that Faretta canvas and make sure that we have a clear record, since there are certainly issues that have transpired in this case as a result of there not being sufficient orders on file and sufficient records having been made. And so I'm going to make sure that the I's are dotted and the T's are crossed as we go forward in this case. So I don't know if there's anything that you would like to say, Mr. Marchese, as far as your position on this, if there's anything that you would like to add, but based on the fact that I don't think that there was really even an attorney-client relationship that was created as a result of the short period of time, and based on the fact that Mr. Sachs threatened you essentially with reporting you to the bar and calling and harassing your boss, I don't know that it would be good for you to continue in this case. So my inclination was to allow you to withdraw.
The court is correct. There was barely an attorney-client relationship that was established. If the court remembers, when I was appointed, he asked when I would contact him. I said it would be within 24 hours. I did contact him the next day outside of the 24 hours. I didn't get his contact information from Mr. Goodwin until after then. I sent him a brief email just kind of outlining I was going to look at his file, get acclimated to it, and then I would call him the next day. He sent a very long negative email back to me stating he would not accept me as his attorney because I was not competent, I was not qualified, etc. And then that's when I said, okay, well, then I'll just withdraw as your attorney. And then he kept sending me emails asking me to file all these things. I said, I'm not going to take any action on your case until the court rules on my motion. So that's where it was left off at. I am happy to try to make an attorney-client relationship with Mr. Sachs, but it's a two-way street, right? Additionally, in between and seeing some of his filings and seeing some of the communications going back and forth, I did suggest to him that based on everything that I've seen with the history of this case, that maybe it might be best if he just goes and represents himself, and I can remain on a standby counsel to try to assist him in whatever it is that he needs, because, you know, obviously he likes to file things and he feels that he has a knowledge of the law, even though he's not an attorney, but he's going through all these steps. I see that he did FOIA requests and he's researching the law, etc. So I did suggest that to him, that might be best, because obviously there's been some issues with prior attorneys. And, you know, it does seem that they have a difference of opinion on how this case should be tried. So maybe he should just entertain that avenue.
Okay. I will hear from Mr. Sachs.
I object to your statements earlier as far as I don't have access to the court. I gave you case law, constitutional case law, that I actually do have a right to have access to the courts. And as far as my filings being characterized as frivolous is completely absurd. I spent a lot of time on those documents. I researched the law, and I very carefully outlined all the violations from the past hearings that have occurred by the court and the prosecutor. These are all fact-based. And so for that to be characterized as frivolous is absurd. And as far as Mr. Marchese having some kind of perspective that he shouldn't have filed it for whatever reason is that I'm allowed to be in control of my defense to the point that I get things on the record and make a complete record. So therefore, he completely sabotaged me. I have absolutely no confidence that he's ever going to, even as standby counsel in that capacity, be say good for me or anything else. I don't actually just don't believe he's competent, and I laid that out in the request, and it was all fact-based. I took the information from the internet as far as his 2015 letter of reprimand from the Nevada bar, which he admitted guilt. He had very bad public feedback that was consistent with his September 26th filing in Pacer of a civil rights lawsuit that this Mr. Marchese threw this individual under the bus. So I don't need that kind of individual. I believe, again, as I say, I'm saying this for the record, that I believe Mr. Marchese was basically installed and put in place as a retaliatory measure because this whole court has retaliated against my wife and I consistently for 6+ years. And what I've come to find out now is that this court and the hospital, UMC Children's Hospital, are owned by the same owner, Clark County. And so there's an inherent conflict of interest going on here where Ms. Rinetti is the de facto counsel for the hospital. This whole proceeding, this whole case is just completely tainted from beginning to end. There is no way that I'm getting any fair justice. And I see it in everything that's being done with the attitude that I need to circle the wagon insofar as bringing it into full context that Dr. Richard Semelka's January 13th, 2025 letter, his four-page expert report makes it crystal clear that UMC Children's Hospital poisoned our son with gadolinium, and he was diagnosed by Dr. Semelka, the world's #1 gadolinium toxicity expert in the world. This man has impeccable credentials. That our son has gadolinium deposition disease. So you even admitted, the court admitted that at the end of the September 5th hearing, the evidentiary hearing, that would change the tenor of the proceedings. Well, I haven't seen that change at all. And all I did see after that was a shotgun hearing on September 8th. And so I feel that there is absolutely no justice going on here. And there continues to be incredible bias against my wife and I. And under no circumstances do I accept Mr. Marchese as standby counsel at all.
Are you finished?
Yes.
Great. I will address everything. And since I let you say your piece, I will say my piece with no interruption. Okay. All right. First of all, I'm going to take things in reverse as far as the tenor of the proceedings. The court did not say that the tenor of the proceedings would change with Dr. Semelka's testimony. What the court did is the court found that under a Hallmark v. Eldridge standard, that because Dr. Semelka was part of the community of doctors, and there was testimony from the state's expert when the court very specifically asked whether or not Dr. Semelka was still considered part of the community of doctors, the response was yes. And since he was still considered part of the community of doctors, and because he had peer reviewed literature, the court made a finding that because of that, it would be up to the jury as to whether or not they were going to accept Dr. Semelka's version or if they were going to not accept Dr. Semelka's version. So to the extent, Mr. Sachs, that you put in your motion that this proves unconditionally your version of what transpired, that is not an accurate statement. What it does is it allows the jury to make a finding one way or the other as to who they believe. So what the court said as far as changing the tenor of the proceedings was that if the court were to go forward with the matter, with allowing Dr. Semelka's testimony in, and the Supreme Court were to decide that it was improper for the court to do that, and if the parties were acquitted on that basis, that there would be no basis for the state to continue with the case because double jeopardy would have attached. And therefore, since the state indicated that they were going to file a writ against me, not an appeal, but a writ, which becomes very important in the context of your filings, Mr. Sachs, that the court was going to grant the stay. Now, in your filings, as you say, that everything is, that you looked everything up and that on the internet and everything is related to a legal argument. I will say this, the internet is not a legal argument. There is AI on the internet that provides with false citations. There are hallucinated sites. There are people that make up arguments on the internet that are not the law. As people like to say, your Google search does not take the place of my law degree. 177-015, which I am going to deal with your motion to vacate the unlawful stay of proceedings. In 177, you cite to 177-015 deals with appeals. They did not file an appeal. They are stating that they are going to file a writ. The court has the authority to grant a stay of criminal proceedings pending a writ being filed by the state. See Nevada Rules of Appellate Procedure, Rule 8. As it pertains to the court issuing the bench warrants for the violation of the pretrial release conditions for seeing your child. NRS 178.4845 was adopted in 2021. It is a new statute. As such, it is not retroactive unless the statute specifically made it retroactive. As such, the prior pre-release conditions would still apply, and 178.4845 would prospectively apply to any new conditions. And in any event, it would not be automatic, but instead would have had to have been something brought to the court's attention. Since it never was, the court's issuing the bench warrant for a violation of the pre-release condition was not without legal basis. As to the other basis, there is no evidence of the allegations. Therefore, the court denies the motion to disqualify Ms. Rinetti. I will further state again, your argument that the evidence now proves gadolinium deposition disease is untrue. That is the position of Dr. Samelka. The state's expert disagrees. It will be up to the jury to decide. That is what this court ruled. But it's also the basis for the granting of the writ because the Supreme Court may decide that this court was wrong in not striking Dr. Samelka. All of your motions that were filed prior to this court allowing Mr. Marchese to withdraw are in violation of the rules and constitute rogue filings because you are still, up until today, you were still represented by counsel. So as it pertains to the motion to vacate the unlawful stay of proceedings, the emergency motion to disqualify Chief Deputy District Attorney, and I will say this, there is the executive branch, there is the judicial branch, and there is, executive, judicial, legislative, thank you. Executive, judicial, and legislative branch. To the extent that your argument that the judicial branch of which Ms. Rinetti is a part of is somehow representing the county hospital, that is incorrect and doesn't provide a basis for her to be disqualified in this case. So for all of those reasons, the court is denying the motion to disqualify Ms. Rinetti, is denying a motion to vacate the unlawful stay of proceedings, and is denying the hearing and fraudulent issue of bench warrants. I will hear from the parties on the motion to set aside or modify the no contact order. And I will grant the motion because it seems like for whatever reason, I think Mr. Marchese would not be being employed by the office that he is employed by if he was not a competent and capable attorney, but to the extent that there is already a breakdown in the relationship, the court is going to allow Mr. Marchese to withdraw. I will not appoint you as standby counsel, Mr. Marchese. I am going to set this matter for another hearing, for a Ferretti hearing, so that Mr. Sachs can go through the Ferretti hearing again. And if we do that, then we will appoint standby counsel at that hearing, if the court allows Mr. Sachs to represent himself, understanding that Ms. Zhang is still represented by Mr. Shetler, and his right to represent himself does not give him a basis to attempt to make filings in Ms. Zhang's case. He can certainly join in whatever you file, Mr. Shetler, but him filing independent things in trying to represent Ms. Zhang will not be tolerated by this court. So that is my position on those three motions. The court has not read or reviewed the additional motions that were filed last night. Will allow, and to the extent that Mr. Sachs indicated that he has cited to case law that provides him with the ability to have access to the court, that would be a correct statement in and of itself, unless he is represented by counsel, which he was represented by counsel, which means that under our rules, he is not allowed to simply file into the case. However, since he is now not going to be represented by counsel, and we are going to continue this matter for an additional day to have a Ferretti hearing and do another Ferretti canvas, the court will allow Mr. Sachs to file into his case with the understanding that any documents that are filed will need to have legal and factual basis to be supported. So those other three motions will be denied. I will hear on the motion, since it was your motion, Mr. Shetler, on the motion to set aside or modify the no contact order, and the motion seeking access to the passport. Mr. Marchese, you are free to go.
I was going to ask if I may be excused. Thank you, Your Honor.
You may be excused. As it pertains to this motion, a couple of points that I would like to make. I will note that the court had previously allowed the passport to be returned to Ms. Zhang. There was a condition on the return of that passport that she signed off that she was not going to have contact with the minor child in this case, which when I thought about that, when I got this motion, it made it very interesting to me that at the last hearing, that everybody was attempting to make the argument that the no contact order was not valid, because if the no contact order was not valid, then there wouldn't have been a requirement that Ms. Zhang sign off to not have contact with the minor in order to get her passport back. So to the extent that the parties made an argument at the last hearing that they didn't know that that no contact order was still in place, the facts belie that statement, because obviously she would have gotten her passport back had she signed off, and therefore she knew that she was not supposed to have contact with that child, Mr. Shetler. And I wish that the state would have provided me with something, because all I have is arguments of counsel that the CPS order was still in place. I would love to have an order from CPS that says that they're not supposed to have contact with the child. I don't have that, but there is now currently an order in place. And quite frankly, you don't get to utilize a violation of an order to establish that the child is okay. And as it stands right now, the arguments that are being made are, well, he's now in China with his dad. Dad can't take care of him and he's not okay. And he was okay when he was with us, but nobody allowed CPS or a guardian ad litem or anybody to come in Arkansas to make sure that he was okay. Instead, they just put him on a plane and shipped him out without anybody laying eyes on him. So from that perspective, the court finds that the prior no contact order, your clients knew. They knew they weren't supposed to have contact with this child. And as it currently stands, the court has no faith that he is okay or that he was okay. So I will hear from you, Mr. Shetler, but my inclination was to deny the motion.
Thank you. I think that what's critical and what's most expedient for the minor is to focus on where we're at right now. What I understand is that there is medication available in the United States that his father can't get him in China. That's what precipitated this. I know that this court reads the paperwork.
Yes.
I had a concern about how this court might receive this request in light of the recent history, just as you just outlined. I don't know, considering trying to keep the best interest of the minor at the forefront and disregarding the other issues that just for purposes of argument, not disrespecting them.
No, I understand.
I don't know if a doctor's note that's a little more substantial might be helpful. I don't know if we could have maybe a doctor here see him. I don't have that authority from my client. I'm not making that offer. I just understand, how do we fashion what I understand to be relief this child needs in a way that this court's comfortable to ensure things go down exactly the way they need to go down. And that's the only thing I can come up with. I understand Ms. Rinetti does have some contact and some medical input, but it would still, I think even with her information, we would still need someone to actually have a consultation.
Well, my thought, for what it's worth, would be to, I don't know that I have the authority to appoint somebody in Arkansas, but my thought would be to get a guardian ad litem appointed for this child.
Problem is the child is in China.
I know if we brought the child back.
Yeah, you can't force, like the court said, you can't force Arkansas. I will say this, do you mind if I? Attached to their motion was a doctor,
Yes.
Dr. Samalka, but there was also a doctor who worked at the Arkansas Children's Hospital. I reached out to that doctor to confirm that that child had been treated. It is concerning to this court that this doctor had no idea about the litigation that was going on in this case, and assuming this child was being prescribed anti-seizure medications by this neurologist. And he just assumed that the parents were giving the child the anti-seizure medications because he never thought to ask that the parent wouldn't give the anti-seizure medications. But as you know from the history of this case, that's why this child was in the condition, because the child wasn't getting the anti-seizure medications. I did also learn that this child, again, has been warned by his neurologist about the concerns about doing titrations with Dr. Smelka, and that this child actually has a genetic issue that predisposes him to seizures. And so that's really the concern. It's not the gadolinium. It's really about he's got a gene that predisposes him to seizures, and they have to monitor them and have medical care for that. So that can be done in China. There's no information that can't be done in China. And so to come back, because, you know, they want to go see Dr. Samelka and do titations, as we can, their treating neurologist says, you know, can't stop them from seeing Dr. Samelka, but it's not about gadolinium. It's about this child having this gene regarding the seizures. And what's really concerning to the state is, I know this child's much older now, right? Well, this child, according to the neurologist, is neurologically deficient. According to him, you can't tell if this child's nonverbal or if there's a language barrier, but there's also cognitive delays because of the issues with the seizures. This child's still experiencing seizures to this day. He has seizures every month. And so that's the state's great concern, is that the history of these defendants throughout prior to even this case being filed, the basis of why this case was filed and throughout this litigation is they don't follow through with orders, whether it's from medical personnel, child protective services, law enforcement in this court. And now we have a child that's medically fragile. And they're basically playing ping pong with them so that the agencies here to protect children don't get to see them. So I think this court is absolutely correct that these defendants have given this court absolutely no assurances that there'll be any conditions related to this medically fragile child. And so we're asking that no contact order remain.
Briefly, I understand that Ms. Rinetti has spent a great deal of her career fighting for kids, and I don't doubt anything that she just mentioned about the child's medical condition. Unfortunately, it's two lawyers talking about medical stuff, and I think that we need an actual medical person to either put on paper or to make a report after seeing our child. And so, again, I don't have that authority. I don't want to waste your time repeating my argument, but it's not shocking to me in my personal experience with other clients that somebody in China is not getting the care they need, especially somebody who might be in less than peak physical and mental health. So that my experience has been that those are not priority patients in China. So I would ask that we somehow figure out a way. Maybe we need more medical information from me, maybe we need it from the state. To get him here to at least know that we're doing the best we can for him, and it may be that the GAL is an appropriate way to go. I don't know. I don't have an answer to that. I know that I'll have some pushback from that. I understand from my client, but as I stand here today, what my client has said is it's critical that he gets back here to get care that he's not able to get there. And unfortunately, all I have is her testimony as a layperson, a mother, and we can talk about who gets to choose what medical care and all that thing. That's a different issue. That's one of the reasons we're here, but it is operating in a zone where we don't know what the hell's going on. No matter if I could talk.
But in part and parcel, Mr. Shetler, part and parcel is because your clients did what they did. Instead of bringing a motion and allowing this court to make findings and to potentially get CPS's eyes in Arkansas on that child or have a guardian appointed for that child in Arkansas. Instead, they sent him to Texas, put him on a plane and put him back to China and then file a motion.
It is.
I mean, it's completely backwards of the way that things should be happening in this case.
It is a problem, Judge. I recognize that, and in a different set of circumstances, maybe we could have proceeded differently. It was all news to me. There was the previous passport issue, and there's things that took place, but we're still in the same place. We still have this minor child who they're saying needs medical care that he can't get in China. And to me, I know this case is a burden on everybody. I know it's a burden on my client. I know it's a burden on Mr. Sachs. I know that your staff, everybody in this courtroom knows this case in and out and has known it for long enough for a child to almost be emancipated. But we still have a child that we need to check and make sure is okay. That's my best argument I could come up with, Your Honor. I think it's the right argument, despite all the other excitement and sometimes blowing the tappet in this case.
So we have no information other than her word that this child's not getting medical care in China.
So I would need a couple things. I would need a letter from a doctor in China that says that he cannot get the medical care that he needs. I would need somehow for us to either have CPS in Arkansas or a guardian, but somebody needs to get eyes in Arkansas on this child, because I'm not going to simply release the child back to the parents on the basis of a doctor's letter that says that he's been seeing him and that he's okay when he's unaware of whether or not the medications have been provided. So, or she, I believe it was a female doctor. It is a he, okay. It also, and I don't know if anybody saw this, but it was quite concerning to the court when I looked at the records of the titration records. I don't know if you all noticed this or not, but the gadolinium was low. What I was concerned about was the lead and the thallium levels were through the roof. So I'm a little bit concerned about there potentially being something else that's going on with this child as far as him having been exposed to something else that I'm unaware of. But until we come up with a plan, I'm certainly not going to simply release the child back to the parents based on what this court has been presented as of today. I am certainly willing to work with everybody for the benefit of the child to come up with a plan that makes some sense. But right now, we don't have that in place. So what I'm willing to do is to set a hearing date whereby we can have additional information on these issues to coincide with the phoretic canvas that I'm going to do with Mr. Sachs that will also provide the court the ability with time to be able to get standby counsel as well, if that's something that Mr. Sachs is going to ultimately want, and or to get actual counsel if the court finds that his phoretic canvas is not acceptable to this court for him to represent himself.
Your Honor, would it be possible, and I have not talked to my client about this, to see how quick she could do this? If we had the passport back, since we now know where our minor is, if she can go and coordinate this letter and this issue in China, while she also is able to attend to her relatives who are not in Twinell. And I don't know if that could happen in a couple of weeks or not, but
I would make it a limited lifting of the no contact for the purposes of her seeing her parents and taking the child to the hospital. So, or to a doctor. So it would be a supervised visitation with a doctor is the most that I would be willing to do at this time.
It seems
Excuse
just
me.
concern is
Excuse
that
me,
Hold on.
we can't really monitor that she'll abide by that when she goes to China, right? And then.
Well, I'm gonna leave it up to the dad. The dad has a right to make sure that the child is taken care of, and so, I mean, I understand, but my concern is for the child ultimately, and if he's not getting the treatment that he needs, Ms. Rinetti, I understand your concerns. I will say this, and I'm going to be very, very, very crystal clear. There is a no contact order. I am going to modify the no contact order for her to have one supervised visitation for the purpose of her being able to take the child to a doctor or a hospital, so that that doctor and or hospital can provide this court with evidence that it is not possible to be able to take care of the child there in China. If there is anything else other than that, i.e., if that child gets put on a plane back here without this court's approval, if anything other than what this court just said happens with that child, I will consider that to be a violation of the order that has been entered by this court, and I will remand your client, Mr. Shetler.
I understand, Your Honor.
I don't know if I can make it any more clear than that.
I understand.
Okay.
when do
So,
I get to take my record?
no, you don't. You're done. I already made a ruling on the other motions. You made your record. I made my ruling, and
You have no subject matter.
your
jurisdiction.
motion, sir. I've ruled on your wife's motion. All you had was a joinder to that motion, and the court is not going to hear anything else. So
I can get the court is to pick a date and I can coordinate with my clients to facilitate that. And if it doesn't work and we need more time, we can certainly let you know.
The one thing that I would like to do is set a date, which I will allow Mr. Sachs to set a date as to when he would like the court to have the phoretic hearing. Now you may speak as it pertains to that, Mr. Sachs.
As soon as possible, but you have no subject matter jurisdiction over our son because our son is an Arkansas boy and we're Arkansas parents. You have NRS 125A.085 and NRS 125A.305. You have no subject matter jurisdiction over our phone or over our son, and what you're doing is ultra
Great,
violent.
then what I can do is remand you and bring you back into the state of Nevada. How's that be? Because then I'll have jurisdiction over you and your son. And he's not your son. He is your stepson, and you have no parental rights to him unless you have formally adopted him, which I don't believe you have. So you want to keep on quoting the law to me? Or you want to come up with a plan that makes some sense?
Our son was poisoned by
I know that that is your argument, sir, and you will have your day in court to be able to make that argument. Mr. Shetler, I will need you to coordinate because when we reached out to the clerk's office the other day, as far as getting the passport back, we were told that they need to be signing paperwork in order to actually get her passport back.
Okay.
So I don't know how that can be effectuated without her being here. I don't know if it's even possible, but the court will release her passport for the purposes of her being able to go and see her parents. I will note that the last time we were here, it was also for the purposes of her going to see her parents. So hopefully she will be able to do so this time.
Thank you, Judge, I'll put somebody to make sure we get whatever we need. If I have a problem, I need help, I'll come seek your help.
And as it pertains to the jurisdictional issues, I tend to agree with Mr. Sachs that I don't have jurisdiction over the minor child at this juncture because he is not here. However, the court still has jurisdiction over this case because the actions took place in the state of Nevada. And so to the extent that this court has imposed as a condition of their pretrial release, a no contact order against them seeing that child, I think we need to come up with a plan because they are seeking to, they don't get to say, modify the order and you have no jurisdiction. Both things cannot be true. So we need to figure out a plan that makes some sense and figure out what we are going to do in this case. The court has made its rulings and I will have you prepare the orders on the 3 motions that were filed by Mr. Sachs as it pertains to the motion to stay, the motion to disqualify you, and the other, what?
The fraudulent granting.
Yes. Okay.
When would you actually predicates?
Okay, let's do the 29th. Does that date work for you, Mr. Sachs?
What time, please?
9:30.
9:30.
The other thing I just want to mention is that Dr. Semelka, Dr. Drake, and Dr. Baker have all seen our son. This notion by the prosecutor that CPS, which in our eyes as parents is a child death organization, and we have a right not to contract with them, is that they have no right getting in our lives. And so we are responsible parents, and we have shown that because if Dr. Drake and Dr. Semelka and Dr. Baker felt that there was any problem, as mandatory reporters, they would have reported us. So this whole thing, once again, is complete bias against us and prejudice, being severely prejudiced with everything that's against us. And we have shown that we actually are responsible parents, continue to be so. So this court is completely out of line. You don't follow the rule of law. I quoted the NRSs, and for you to threaten me with another, remanding the warrants under what specific authority, and then the other part of that would be is Ms. Rinetti gets an unlimited amount of time to appeal this matter with her writ. In other words, there's got to be something even the NRAP rules or the statutes that say you have a deadline to file your writ to the Nevada Supreme Court. So you have been silent on that, and that is prejudicing our rights as well. We have a right to know what the deadline is that she can get that done, because we've been held up for 6 years. We are 50% below the poverty income level, the federal level. Our lives have been destroyed because of this stupidity. So we have a right to have some answers, please. Thank you.
Okay, so as it pertains to the writ, I will say this. Mr. Sachs, we had to get the transcript done first so that the state would have the transcript of proceedings before they can even move forward with the writ. That transcript was filed when, Shannon?
The order has been, my proposed order was sent to Mr. Marchese and Mr. Goodwin before I can send it to your court for the review to sign off on it. I haven't heard back from them.
Okay,
But I may just, since he's now representing himself, I'll just submit the proposed order to you.
okay. And the transcript of proceedings was. Okay, so the transcript of proceedings was filed on October the 10th. Before the state can even file the writ, they have to have the transcript of proceedings, and they also have to have the order from this court. Otherwise, there's nothing for the Supreme Court or the Court of Appeals to even address with the writ, because there is no order on file. So that order was submitted to Mr. Shetler and Mr. Marchese on what date? Or it was submitted to Mr. Goodwin and Mr.
Marchese.
For its brief indulgence. And on October 15th.
Okay, so that was sent on October the 15th. It has not been provided to the court yet. So I will go basically under our rules, under EDCR 7.21, both of the defendants would have 14 days from the date that it is submitted to the court, that the order is submitted to the court, within which to file a competing order on that order. So to the extent that it was submitted to the parties to see whether or not they could agree, technically the defendants would have 14 days from the submission or until October the 29th to see whether or not they could agree on the order and or submit a competing order. So, and that the writ cannot be filed until such time as that order is actually filed. So I would give the parties 30 days after the order is filed within which to file their writ would be the typical procedure that I would give either side in filing a writ. So to the extent that we are looking at the 29th, which is also the day that we are coming back for the Feretta canvas, the court is going to make a finding today that the order will either be agreed to by the parties and or it will be submitted by the state on that date. And if the court believes that the record and the order accurately reflects the findings by the court will sign off on the order within 14 days of not receiving a competing order from the defense. If the court receives a competing order from the defense within that 14-day period of time, the court will look at both orders, and whichever order more comports with what the court's findings were and legal conclusions were, the court will sign off on that order. If neither order accurately and completely reflects the findings by the court and the legal conclusions, the court will create its own order. And generally speaking, I have 60 days to do that. I will not take as long in this case because I understand that the writ needs to be filed sooner rather than later so that we can move forward with this case. But we will address that issue because right now I don't know whether or not you're going to agree to the order. I don't know, since Mr. Sachs is he's not really representing himself right now because he has not passed Feretta as of yet. But I will have the state provide that order through Mr. Shetler So Mr. Shetler will receive a copy of the order and he will provide it to Ms. Zhang, who can provide it to Mr. Sachs.
I'll make sure that goes out this afternoon. Jen.
All
I
right,
believe I think I sent it to Mr. Shetler, but I'll send it again.
all right.
And then apologize, one more thing.
Hold on, I
apologize.
wasn't
Oh,
done.
sorry.
As it pertains to, now I just lost my place. As it pertains to Mr. Sax's statements in regards to threatening to remand him to the extent that he is arguing that this court does not have jurisdiction over his child or jurisdiction over him. If he does not want to, if he wants this court to have jurisdiction and make the arguments that it does, then he's submitting to jurisdiction in this court. So I will address that as it pertains to that. Ms. Rinetti, go ahead.
Apologize, Chairman. Since we're waiting until for the FREDA on October 29th, pending motions that have not been ruled upon, that have recently been filed, if I could just have 10 days from when, if he gets from October 29th to file my opposition. So I won't file it in between, because if he doesn't pass FREDA, then attorney will have to be appointed and they'll have to make the decision. So I could just wait until that.
They will have to make the decision as to whether or not those motions are valid and appropriate motions. So those motions will be held in abeyance at this time. We will do the phoretic canvas. If Mr. Sachs passes the phoretic canvas, then the court will provide the state with the statutory time within which to file an opposition under the criminal rules of practice 9, I believe it is. So we will wait until the 29th and continue everything until the 29th. All right.
Thank you.
I have a follow-up question. Under what specific authority did you seal those non-contact orders, please?
Under the authority of the fact that it has your minor child's name in it, and therefore under SCR Supreme Court Rule 3, which relates to the sealing of orders, because it has your minor child's name in it, I am protecting your minor child.
Just to get this on the record, I completely object to this entire hearing and the fact that you still maintain that the no contact order is that you brought it into being without any due process whatsoever, that there was a hearing.
Mr. Sachs, I'm going to stop you. I brought it into being because, and there is due process, I brought it into being because it is a condition of your release. And under 178.4585, this court is allowed to create conditions of release pending trial. And that is a condition of release pending trial. I could have done it at any time in this case. That'll be all.
Thank you, Judge.
Thank you.